Defamation. Section 9. Damages. Subsection H. Costs. Costs. 22 to 253. General rules about costs are now contained in the Civil Procedure Rules PTS 43 to 48 and relevant practice directions. The question of costs in defamation litigation is particularly significant as one at least of the parties will frequently be self-funded and uninsured. The question of payment into court is therefore particularly problematic. In Rocha v. News Group Newspapers Ltd 1100, the Court of Appeal held that where the claimant had obtained an award of damages for libel which was the same amount as the defendants had paid into court before trial and had also obtained an injunction against republication, the defendants were, for the purposes of costs, the successful parties. The court therefore allowed the defendants' appeal as to costs and the claimant was ordered to pay the defendants' costs after the date of their payment into court. After a page 206. Judgment in favor of the defendant in Hamilton v. Alfade 1101, the court refused to make an order entitling the defendant to recover the costs payable by the claimant from well-wishers who had assisted the claimant financially in the case. 1102, the action had stood a reasonable likelihood of success and the court refused to penalize those who had provided funding to enable Mr. Hamilton to sue when he had not got the necessary financial means and legal aid was not available. Cost capping. 22 to 254. The high costs of defamation actions continue to be a cause of concern to lawyers and prospective parties to defamation actions. Clerk and Lindsell on Torts 20th ed. Main Volume. Chapter 22, Defamation. Section 10. Injunction. Injunction. 22 to 256. As to granting an injunction, see Chapter 29. As a general principle, the so-called rule against prior restraint, in Bonar v. Perryman 1110, has provided that an interim injunction will not be granted in defamation proceedings where the defendant intends to rely on a substantive defense such as justification, fair comment, or qualified privilege. 1111 The claimant, to obtain an interim injunction, has been required to demonstrate practically that there is no defense to the claim with a realistic prospect of success. In Green v. Associated Newspapers Ltd. 1112, the Court of Appeal had to consider the effect of S.12.3 of the Human Rights Act 1998 on this rule. Section 12.3 provides that interim injunctive relief shall not be granted unless the applicant can show that they are likely to prevent publication at trial. Trial. In Cream Holdings v. Banerjee 1113, the House of Lords decided that likely means more probably than not, so that the applicant merely had to show that their claim was more likely than not to succeed in order to obtain interim relief. Although Cream Holdings was a breach of confidence case, it was argued that it was of equal application in defamation cases. The applicant relied on a subsidiary argument that even if the Cream Holdings test did not apply to defamation cases, then in any event the rule in Bonar v. Perryman lent undue weight. Page 208. To freedom of expression. The Court of Appeal rejected both arguments. The court considered it justifiable for there to be a less stringent test in confidentiality cases because in such cases, once the information is published, the confidentiality is lost forever. The possibility of vindication at trial in a defamation case gives the claimant the opportunity to restore their reputation. Furthermore, to allow interim injunctions more readily would often be unworkable, because it is impossible at the interim stage, when the judge only considers the evidence on paper, to make any proper assessment of the merits of a defense of justification. For example, regarding the second limb of the argument, there was nothing in the European Convention on Human Rights which required the rule in Bonar v. Perryman to be changed. Whilst the courts recognized that there was a balancing exercise to be carried out in assessing whether or not the applicant was entitled to an injunction, the balance did not come down in her favor. Her reputational rights could not be afforded great weight when compared to the public interest in the freedom of the press to report on matters in the public interest without the threat of prior restraint by injunction. 1114 Where the claimant succeeds in satisfying the requirements for an injunction under Bonar v. Perryman, an injunction should not be refused solely because primary publication has occurred if the injunction could effectively prevent further dissemination of the libel. However, there must be an urgent need for the injunction, and where the defendant has indicated that it does not intend to publish the defamatory material, an injunction is likely to be refused. 1115 In British Data Management plc v. Boxer Commercial Removals plc 1116 the Court of Appeal confirmed that a quia timet injunction may be issued to restrain the publication of a threatened libel in a case where there is reasonable certainty as to the words of the publication.
responsible. Okay. Okay, so with that, we have completed Clerk and Lindsell. So thanks again for joining us for this very important course on libel and slam for journalists. And we look forward to seeing you as we move on to Gatly. Okay, that's Gatly. All right, so we could start reading up Gatly, free trial applications. Okay, see you next time.